Roger Citron. I'm an Associate Dean and Professor of Law at Touro University, Jacob V. Fuchsberg Law Center. I'm here today with my colleague from Touro, Thane Rosenbaum. Delighted to have Thane with us today. And this podcast today is a Touro Law Review podcast, and we'll be talking about several cases that the Supreme Court recently decided. Before we turn to that, Thane, please tell us a little bit about yourself.
Well, Roger, in addition to being a friend and colleague of Roger Citron, I have other things I can say. But briefly, I oftentimes think that I'm a novelist moonlighting as a law professor. Roger's the real thing. I only play one on television, but I do have several gigs in addition to my affiliation at Touro, which I'm very happy about and proud to be part of, an incredible community of students and scholars, and just wonderful people. I'm also the legal analyst for CBS News Radio, and I often write essays and articles about the legal system itself, and have written a number of books that have taken I would say, a moral critique of the legal system through various different avenues. And I think it's just about enough about me.
You are both very busy and very productive. So I know that from, among other things, following you on LinkedIn. And of course, the Supreme Court has kept all of us busy, those in the law professor or law profession. And we want to talk about, probably we'll spend most of our time now talking about the abortion decision, the Dobbs case. And I guess starting there, Chief Justice Roberts, who voted with the majority, wrote separately in a concurrence that he would have had the court uphold the Mississippi law without completely overturning Roe versus Wade. But he was the only person who held this view. Why did the majority go further and overturn Roe in this case this year?
Roger, such a great question. And oddly, the kind of thing that Justice Roberts wouldn't like to even be associated with the court. It's an interesting political question. The politics of the court, as opposed to just the judicial reasoning and philosophy of the court. What was the politics within the courthouse itself that led to such what I would call a strange outcome? Because remember, Justice Roberts is a classic institutionalist. He believes in the institution of the court, which is one of the reasons, in addition to being the Chief Justice, why he's so upset. I don't know if he speaks of it publicly, about the declining public confidence in the court. He knows that in polling, the court is not doing well, and it's upsetting to him because he doesn't want the court to even be on the people's mind as a political entity. He wants it to be separate and apart as its own branch of the government that does one thing. It's merely interpreted the law, balls and strikes, as he likes to say from his Senate confirmation hearing. So as an institutionalist, he's thinking, and he's probably said this to the other 5 conservatives, hey, everyone, I thought that when we make changes, we do it in incremental ways, right? So there's like a long history in the Supreme Court. For instance, civil rights. It took 10 years of Supreme Court decision-making, cases brought by Thurgood Marshall when he was with the NAACP Legal Defense Fund. It's a fascinating story. Long before he was a federal judge, Marshall was arguing cases, civil rights cases, but very incremental, chipping away at laws, state laws, that eventually led to Brown versus Board of Education, that eradicated the separate but equal segregation within public schools. And then, of course, Chief Justice Ginsburg, her prior career, she did the same thing. She took a very incrementalist approach on behalf of arguing cases dealing with anti-discrimination cases against women, and chipped away at pieces of them, even when it came to discrimination against men, as a way of eventually evolving the law into taking a very strong position about equality for women. So I suspect Roberts, in filing his own concurrence, was sending a message to everyone like, hey, I'm not part of what they're doing. I think they went too fast. I wonder why. What's the fire? If you really want a solid foundation to overturn Roe v. Wade, let's take up a number of these cases over the next few years. And then if you feel strongly enough to overturn Roe v. Wade, let's do it the way the Supreme Court normally rolls. But this is not how the Supreme Court normally rolls. So again, when I think about the concurrence, I wonder how much infighting there is among the clerks, among the justices themselves, even within the conservative wing of the block of the court, where he's saying, this is just not the way we do it. This was a really sudden, harsh, extreme overturning of settled principle, and the same thing could have been accomplished over a number of years. I guess the argument you could say for the other five is, hey, buddy, the world has changed and everything is political nowadays. And we don't like to think of ourselves this way, but who knows how long Justice Thomas is going to live? Who knows if someone doesn't get hit by a car? Who doesn't know? Who knows? The Biden administration seems to be guided by progressive, thinking. We now have Justice Jackson. Who's next? We could lose this 5-person majority in 6 months, a year or 2 years, and we're not thinking the way they thought with Thurgood Marshall in the 1950s and 60s that led up to the Civil War. We're thinking about now. What can be done now, because this is our moment. Let's take a shot. So that's the only thing I can think of. I don't know if there will ever be any books written about, or some law clerk may one day say, you have no idea what was going on. It was madness among the conservative bloc. Even the clerks were angry about this decision.
Of course, we'll get to the decision, and Justice Alito would say, all we were doing was law. And in defense of that, I think that Justice Alito could point to not just what was written in his decision, but in particular, the attack upon Roe that the majority decision does. And of course, I think more than once he refers to that decision, to Roe, the 1973 case, establishing the right to abortion, as exceedingly weak, or in similar terms. Do you agree with that assessment from the perspective of Roe as a judicial decision on a constitutional right?
So Roger, I think he even goes worse than that. I mean, I was shocked. In fact, I think at one point he says egregiously wrong.
Yes.
It's both things together. In fact, I remember for CBS News, when the opinion was leaked in May, one of the things I said, well, that's the first draft. Who knows what it looks like today? For instance, Roger, as you know, I'm often wrong. So I say a lot of things that are just flat out wrong. So I said on radio, nationally, I said, I'm sure when the opinion is finally released, the language egregiously wrong and weak probably will be softened, won't come across as harsh. And he didn't change a word. He said, no, just what Roger Citron said. It's awful. He was saying it was wrong from its inception. So I think that they were taking a very strong position, and that's why they didn't change the 5 that voted to overturn Roe v. Wade. And remember, one thing I forgot to mention, the case originally was brought by Mississippi simply to move the goalpost from 24 weeks of viability of the fetus outside the life of the mother to 15 weeks, right? To say, well, why does it have to be 24 weeks? Why not say abortions after 15 weeks are illegal, not 24, to change the numbers that came out of the trimester concept that came out of Roe. And that's all Mississippi asked for initially. And then all of a sudden they decided to roll the dice and change their case, even in oral argument. I think one of the liberal justices turned to the Attorney General of Mississippi and goes, "Hey, buddy, what are you doing? I thought this was about, I didn't know this was about overturning Roe v. Wade. You're using very different, you're seeking a different request from what we thought." So I think everyone shifted gears at some point about what could eventually be accomplished. So I could say that's probably why the language is so strong, because they don't want to even be questioned at all. Here's why we're doing it and why. And look, what do I think? Look, I think that if you believe that, as he does, that he's dubious about substantive due process, dubious about adding rights to the Bill of Rights that are not already enumerated, pretty sure that the Ninth Amendment doesn't mean you can just add rights to the Bill of Rights. That from the conservatives' perspective, they think that the Ninth Amendment means, well, it just means that for those people that are worried about an all too powerful federal government, it really just means it's really a limited self-government, and whatever's not in the Bill of Rights goes back to the people and through their own state legislatures, which in some odd way supports Alito's opinion, right? Send it back to the people, right? But if you believe in substantive due process, if you believe that there are rights that are unenumerated, that although are not concretely stated in the Bill of Rights and Constitution, but that such as the right to privacy, which we know has led to a series of new protections, from contraceptions to same-sex marriage to same-sex intimacy, and that we thought was Roe v. Wade as well, then if you think that those such rights exist, this is a disastrous opinion on every level, because Justice Thomas, in his concurrence in Dobbs, says, I think we should give some new thought to the substantive due process, the concept itself, and how it evolved with these additional protections, same-sex marriage, same-sex intimacy, contraception, even though the majority opinion says we're talking only about abortion, relax, don't get hysterical. We're not talking about any other right to privacy rights. But I do think that, remember, it was it Professor, I can't remember, is it John Eli or Ellie, the famous.
I always thought it was Ely, John Hart Ely, is how I
John Hart Ely,
learned to pronounce it. Yeah.
So people will point out, conservatives will point out that Professor Ely, as well as Justice Ginsburg, had always said that they thought that Roe v. Wade was wrongly decided, could have been accomplished through just pure equal protection grounds, that it went too far, that it sort of ignored the political process. And so I think that the statement that Alito is saying is, this thing was always on shaky foundation. We pretended it wasn't, and we let 49 years go by, but this thing was always shaky. It was done too fast. It seems like too much judicial alchemy. And so it's time to undo it. So, in order to play it straight, look, I'm pro abortion. I'm in favor of the autonomy of the rights of women. On the other hand, I think that progressives and liberals have made a huge mistake in the way they have dealt with the pro-life community, and maybe we could talk about that as well, because it has resulted in a silent culture war that simmered for 49 years, and you're seeing it breaking out now in a huge way, because it's one thing to say, my body, my autonomy, my body. Yeah, I get it. I understand. I support that. But there's a sizable number of Americans that just don't see it that way, and you're not going to be able to convince them of it. So what do I think? I think it's extremely complicated. I do think the one thing that Alito said that I think is really true is that this is a really political and moral question, right? And I don't know if that means the Supreme Court has no business dealing with it, but I think he's right in saying, let's just be clear, it may have constitutional implications, but it's really, really hotly political and hotly moral. And for that reason alone should be given to the people. Again, I'm generally in favor of the right to privacy. I, for one, would extend the right to privacy. In one of my books, my more recent book on free speech, I feel very strongly that the right to privacy should have morphed itself into a right to dignity. And I think that personal dignity to me is something that we as Americans don't realize that other Western democracies, including Israel for that matter, have dignity right up there. And they repeat the word over and over and over again. And we don't have it anywhere. It doesn't exist in the Declaration of Independence. It's not in the Constitution. So I'm obviously, for that reason alone, I think, no, I like the idea of expanding rights in the Bill of Rights. And I don't have a problem with substantive due process. But clearly, if you do, and you're an originalist, Dobbs is a great decision for you.
Yeah, there's, boy, three or more threads in you just,
Sorry.
I'd like to pick up on. Can I go to I'll pick number two, at least what I have it down as number two, because the idea that how the pro-choice and pro-life, how they perhaps could have talked to each other, now how they may have to talk to each other, in the aftermath of Dobbs. And the only thing I sort of, I wanted to ask was, there's a book I read in college, the Kristen Luker book, and it sort of said, but they can't really talk to each other. At least that's my paraphrase, in the sense that there's no compromise to be had. And I just wanted to sort of, take the chance to have you expand a little bit on, how you think we could talk to each other in a politically, because now abortion is a political question as well as a legal question.
No, it's a good question, Roger, because what you're saying is now, because of Dobbs and the Alito decision, we're being forced to talk about it, right? We're being forced for it to be introduced into the public sphere, have it be part of elections, both for state legislators and for state judges. Many state judges, even Supreme Court judges, are elected. So you can imagine that how Dobbs, the aftermath of Dobbs, is going to be part of people's political platforms all throughout state elections for both legislatures and state courts, including the highest courts of the state. So I think the one thing that hasn't worked for sure, again, it may be that it's hard to talk about because there's no compromise. I actually always thought pre-Casey, right, that changed the standard to focus less on the first trimester and more on undue burdens. But I thought Roe had it right to say the first trimester belongs to the mother to make decisions on her own personal autonomy. And then the next 2/3 of the experience of pregnancy is a state interest, the life of the fetus and other issues related to the state. And it did, to me, it's not like the lemon test when it comes to another strand of the First Amendment with, say, the Establishment Clause, but it was sort of like a lemon test. It was a balancing approach, right? It sort of said, here's how we're going to balance this out. You get the first trimester. Now, look, if you're pro-life, you're saying the minute you detect a pulse, a fetal heartbeat, the minute you can hear anything, that's a life. Okay, there's a lot of conversation that's left on that because there's a lot of argument about, does the fetus feel pain? Does the, like what experience does the fetus have? At what point does it become a living, and I think that thought was, well, when it can live outside the womb, right? That was the idea, that if once a baby can live outside the womb, then it's a person. And until the fetus can cross that threshold, it's a potential life, not an actual life. But I do think what's happened, and you see this played out in the election of Donald Trump 6 years ago, is that there has been this underlying culture war that it didn't just start with Donald Trump. It may have started in the 1960s and 1970s with Roe v. Wade, where, again, there's, in the pro-life community, their view is that taking the life of an unborn fetus is not an example of enlightenment or modernity or the imperative of personal autonomy or bodily integrity or an example of moral superiority. They're sick of being lectured to by cultural elites. And believe me, as a blue state Democrat, I I get that. I feel like I'm the only blue state Democrat who looks at that and goes, stop talking to them like all they know is NASCAR and beer and country music. I know that's how you feel about them, but there's something wrong with you that so degrades half of the country, that you feel so superior because you went to a better school or because whatever it is. And this is what brought Donald Trump. So if you don't want Donald Trump, keep doing it, keep going. Because in my view, the last 2 years since the Biden, it's worse. It's an ongoing trashing of half of the country. Just endless trashing, stupid, backward, unenlightened Southern rubes. And that there's not going to be a conversation at all. So when you say, what kind of compromise can there be? I don't even think there's even a potential conversation unless there's some mutual respect that we understand what you're concerned about, because the more you shout, my body, my body, my body, the more you're drowning out someone who feels very strongly about the life of a fetus, right? You can scream all you want, you can protest all you want, I get it. But what you're really saying to them is that their interest, what they're interested in is of no value. So I don't know how this is going to work out. I think it's a mess, in terms of what we're seeing already. There are 12 lawsuits going on right now, and we can talk about that if you want. But I will say that I don't know. I think it has to start from a place of mutual respect. This is important to us. We understand this is important to you. We have to find a way to make this work in the political sphere, because as it is, the country is so divided. Let's see if we can use abortion as a way to make our common interests known and fully respected. I understand the point you're making is, well, once you have an abortion, no matter what time, it violates the idea of pro-life. But I do think that maybe the pro-life people need to see that that idea is not going to go away, that women are going to want it. And it's not just about preserving the life of women, because to me, of course, that's an issue. But there's all kinds of other issues that are right now unresolved. And I don't know if they can even work their way back to the Supreme Court, like rape and incest, prenatal abnormalities. Are you telling a mother who's saying, I know I'm going to have a baby with abnormalities, and I'm telling you right now, I'm giving that baby away, right? And the state's going to say, I don't know, do we want that? Do we want the responsibility of women literally telling us, I'm telling you right now, Dobbs put me in this position and I am not keeping this child. So I don't know where that's going to play out. Teenage pregnancies. I don't know how that's going to play. We know Dobbs doesn't give us a guideline, a roadmap. I don't know what states are going to do. Morning after pills, right? Look at all these issues. Here's one, Roger. Yeah, prosecuting doctors, but could you prosecute mothers? Could you prosecute women, right, for having the abortion, not just the procedure provider of the procedure, but the woman who made that choice, her pro-choice? So I think a lot is unresolved, but part of it is, to me, can't be resolved unless there's some mutual respect.
This is going to sound glib, but it really isn't meant to be, which is that there's a lot to discuss. Let me try and dial us back or turn us back to Dobbs, because this might have been the first thing that you touched upon in the answer prior to this one, or in our discussion. The draft, which you talked about, I guess, on CBS after it was leaked, that it became public. I thought this was extraordinary, that so much in so many months or so much time before the decision was finalized, that the draft had leaked. And what do you think the draft tells us about the dynamics at the court? And I guess if I can make it a compound question, do you think the draft is a one-off because abortion is sort of so contested that it kind of drove anyone involved in that process of making the draft available or leaking, but that we really shouldn't think that this will become something that we'll see you know, not even routinely, but maybe even again in the next couple of years at the court.
Well, Roger, as you know, how stunningly unprecedented this is, and most people don't realize the Supreme Court has always been opaque and loves it, right? They love, it used to be really until Sotomayor and Ginsburg, no one even knew what any of the justices looked like. Literally for a couple hundred years, no one could, you could bump into one and not have any idea you're standing next to a Supreme Court justice. Only now with, the notorious RBG and, things like documentaries, and Sotomayor is a little more public. But this is an institution notoriously private, and judicial independence and discretion was critical. And so the fact that this is leaked is such a shocking, and you've heard some of the justices, whether it's Sotomayor or Thomas, speak about this horrible, injury upon the court itself. Look, I think that over the last 10 years or so, a lot of people like to focus on the fact that Ginsburg and Scalia were buddies. They didn't agree on one thing when it came to judicial philosophy, but they loved the opera and they loved having dinner together with their spouses. And everyone said, oh, isn't that nice? Oh, wow, that's lovely. Oh, they're spouses too, I see. But I think that what we're seeing now is a much more, down and dirty, look at what maybe is really, it's not Scalia and Ginsburg, that it might be that, again, and I did not clerk for the Supreme Court, so I don't know what it always looked like, but I suspect that there's some enmity between them. There's hostility. And this clearly is an hostile act. However this happened, it's a hostile act, whether it was a justice or clerk or court personnel. I remember saying for CBS, and now I'm starting to wonder again, everyone is still shocked. How come the investigation, the internal investigation, has not yet produced the leaker? How has it been 3 months? And we don't know. There's only 60 people that could have had access to it for the most part. How hard is that to do? Find out who it is. I wonder now whether everyone said it had to be someone who was part of the liberal bloc because they saw what was happening and they wanted to put pressure on the court to change its mind. And that's why they leaked, because they saw that they were actually going to overturn Roe v. Wade. And they decided to do a Joan of Arc and say, I will sacrifice myself for the greater good. And there'll be a Netflix movie about me one day, but I'll never be able to be admitted to the bar. But there'll be a Netflix movie about me one day about how I leaked the opinion. I'm wondering now whether it wasn't a conservative, because I'm thinking if everyone knew that Roberts wasn't going along with the overturning of Roe v. Wade, but was simply interested in preserving the 15-week Mississippi abortion line. I think that the more likely swing vote nowadays is really potentially Kavanaugh. And I can imagine some conservative clerk saying, I'm worried about Kavanaugh. He's too soft. He might jump with the chief and say, you know what? I'm an institutionalist too. I clerked on the Supreme Court. I know the way we roll. And this is a little too much, too fast, too soon. And I'm going to go with the chief. And then, of course, at that point, you don't overrule Roe v. Wade. And maybe the way to lock Kavanaugh in would have been to leak the opinion. Look, I don't know. I'm just saying that I don't think there's anyone can overestimate, what a devastating attack this was on the institution from within. Such an act of hostility, and suggest when you say, could we see, I think we're going to see more of this unless they come up with protections. Now there's a precedent. I think that, look, you've got people that are protesting outside of restaurants, in DC. The passion is very, very strong. And clerks and personnel are passionate people too. They're not there just because they made law review. They're there for lots of reasons. And for them, especially when it comes to the right to privacy, these things are sacred. And I can see that the chief is going to have to come up with a way to prevent this from happening, because apparently it's too easy to do. It's just that no one ever thought to do it before. It would have been unheard of, unimaginable. The respect for the court itself was too large, but that respect has now been devalued, degraded. And I'm saying now that it's happened, it can happen again, especially now because progressives are saying no matter what the majority opinion said in Dobbs, same-sex intimacy, same-sex marriage, contraception is on the table again.
Yes, and the yes is, I think in discussing with some faculty colleagues, I thought the leak was, keeping in mind that I graduated from law school in 1992, right? It was a Bush v. Gore moment. That is, it sort of approached that level of shock, well, I'll stick with shock because it's remarkable for the way in which it both crystallized and generated, the conflict at the court itself, and in an open and sort of public way. That is, it was there for everyone to see.
Can I just add one thing to what you just said? No, I love what you hadn't thought about that until you shared that Bush v. Gore moment that you had with colleagues. But it's interesting, Roger, that two things that happened in both of those cases. One was in Bush v. Gore, the opinion at one point said, this is a one-off. Don't read, this is it. This will self-destruct like Mission Impossible. As soon as this opinion is read and is applied and the vote in Florida is counted, is just, Bush is now the president, and Bush v. Gore can never be used as precedent again, explodes. I don't know if they have the right to do that, but they did. And also in this opinion too, it had a Bush v. Gore moment, because that's exactly what Alito says when he says, relax, relax, relax. We're only talking about one right to privacy. We're not talking about more right to privacies. Don't worry, the other ones are still protected. And so it seemed to me that that language of, we understand how huge this is in Bush v. Gore. We understand how huge this is. So just recognize we get it and we won't do it again.
And we'll see. And I say that, with complete, sincerity, which is that, judicial decisions tend to take on a life and force of their own. So we'll see. I want to pivot to the Second Amendment case from here, because this is the Bruin case, which, to oversimplify perhaps a bit, right, took a very robust view of the Second Amendment as an individual's right with respect to handguns or arms, or however we want to terminize guns today. And the question that I think sort of comes up is, well, wait, in Dobbs, you just said the people can decide that, which means the electoral process, the state legislatures, and so on. We're giving the issue back to the states. In Bruin, of course, you had a law passed by elected representatives in New York, and they said, and the court said, that's invalid. That's invalid. And are the cases inconsistent? I'll leave it at that.
It's an interesting point, right? On the one hand, the people decide. On the one hand, oh, no. It's a federal law. I guess one thing that Alito would say is, well, abortion is not in the Constitution. Guns are, right? Guns are the Second Amendment, and social conservatives and conservative justices have for 49 years saying, where are you getting this right to privacy? Where did you find this? I'm looking, I don't see it. I looked here, I looked there, I can't find it. And so where did you invent this stuff? That's what, conservative justices have been saying. And after Heller, the case in 2008 that finally said, again, I don't know if that's wrongly decided, but conservatives finally said, no, 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 no. Well-regulated militia doesn't just mean a militia. It also means private gun ownership. And in Heller, it said private gun ownership for just self-defense purposes for law-abiding people inside their home, not anywhere else. And then it took 14 years until the Supreme Court finally came with this new opinion in Bruin that said, and it's outside the home too, if it's for self-defense purposes. So if you believe, as does the Supreme Court, that the Second Amendment applies to private ownership of firearms, then they're saying, well, the reason it's not a state issue is because it's in the Constitution. It's federal, and that's our job. We're Supreme Court justices to interpret the Constitution, and we're not going to let states infringe on a right that's constitutionally guaranteed to all Americans through the central federal government. Whereas they would say, abortion, I can't find it. It's been around for 49 years, and yes, it became settled precedent, but yes, radical surgery. We did this thing in Dobbs where we excised this unenumerated right as part of the right to privacy, the panoply of rights. We ripped it out surgically because it wasn't really supposed to be there in the first place. So, again, is that a distinction without a difference? For most people, they're going to go, I don't get it. Why is this right something that you say can't be taken away, as in guns, whereas abortion rights, which is really, really important to at least half the population, are saying, but that can be taken away? And I think that, from a strict, constitutional perspective, I suspect the conservative justices is, yeah, it's not our fault. The Constitution was written originally with this language, and it didn't contemplate the rights that you think you have over there, but it definitely contemplated guns.
And the originalism piece, because certainly both cases establish that there are at least 5 justices, perhaps sometimes 6, who embrace, endorse, apply originalism in cases involving constitutional claims. I'm going to go back to, when I graduated law school in 1992. Originalism was there. That is, it was a theory. And I suppose that Justice Scalia certainly endorsed it. And then Justice Thomas, during my last year of law school, was nominated and confirmed. So that was 2. Where do you think we're headed with originalism on this court? And what does it mean really for all of us in the legal profession if we're going to keep up with the court as it goes back to or endorses originalism?
Roger, here's a question I was going to ask you, because you're a lot smarter than I am, because I actually think that there's something that comes out of Bruin and Dobbs, which to me is an interesting conundrum. And I'm going to turn this question back to you, which is, it seems to me that that's Alito in Dobbs and Thomas and Bruin both used very similar language that requires, again, a big legal brain, like a citron brain, where you have saying, well, wait a minute, no constitutional right really exists unless it's embedded in American history and culture and traditions. Both of them seem to be saying that, right, in a way. Alito is saying abortion is not part of the cultural traditions of this country. Like, the founding fathers didn't even know what it would look like. Like, there's no way that was part of the Bill of Rights. There's no history that even in the 19th century, this is something that showed up, in the late 1960s as part of a whole wave of civil rights and civil liberties that come throughout the Warren Court, some of the Berger Court. We saw this just giant wave expansion of rights. Even our expansion of the First Amendment expands greatly in the 1960s. So it's sort of an anti-originalist approach takes place if you really believe only in the text of the original documents. So it seems that both Thomas and Alito are both saying, and by the way, Thomas is saying something else about gun ownership. He's making a kind of Wild West argument, saying, give me a break. Has anyone watched any classic John Ford movies? Has anyone watched Bonanza or Gunsmoke? This country was based on people carrying a gun in a holster with bullets. Can you be more upfront about, there's no concealed carry. Watch any American movie of a certain era or show. This is all we do. In fact, other countries around the world laugh at us for that reason. Oh, those cowboys. They refer the Dallas Cowboys. I mean, it has a very strong, metaphorical association. What does it mean? It means a guy who shoots from the hip, literally, and he's got a gun and it's open and it's not concealed. So I think, Thomas, and that's why I'm asking you, I don't know, is that what he's saying? Because it is ironic that I know that from some of those movies, by the way, occasionally you get a sheriff that says, you can have a gun, but you can't carry it in town. I don't want you going into the saloon. You give me your guns and I'll hold them. And then when you leave town, I'll give you your guns back. I've seen movies like that. And I wonder, well, wait a minute, isn't that a tradition of gun regulation from the 19th century? Where like Wyatt Earp, I think that I am right about this. I think it was Wyatt Earp. I think he and his brothers at one of those towns said, this is a no guns when you're near a saloon or a brothel, any place where you get nutty, we will not let you have a gun. Maybe that's an example of, yes, we've been regulating gun ownership all the time. But I do think that this originalism argument seems, after this year, it's going to really raise the salaries of legal historians. The people that are legal historians should really jump in now. All right, we got to really talk about the history of law in this country. And do you have any thoughts about both of those opinions and the language that they use?
Yes, and qualifying them as I must, because while I'm very interested in legal history, generally, I really don't know more than what I read in Bruin about the history of gun ownership and gun regulation. So the first point, with that caveat or qualification, and I'm going to invoke my Toro Law colleague, Tiffany Graham here, because we did an event with students to talk about the Bruin case. And one of the things that she said there was, we're all going to need to be historians. Certainly those who teach or practice teach practice in the area of constitutional law in this way. And I think that I took that comment the next day when I was talking to a student from my first year civil procedure class, and I said, I hope the JD won't be enough if this is something that interests you. You're going to have to find room for a master's in history. And it was a joke, sort of, as we say. Mm-hmm. And I think that what Professor Graham was saying, in some ways, was, originalism as applied in these two cases really raises, forgive the expression, right, raises the bar for all of us, in that we really may have to go down historical pathways to try and make an argument about interpretation, and how these the Bill of Rights was understood in 1789 and so on. The second point, I think, which goes to the Bruin case, if you will, the Second Amendment guns piece, I think that I mean, this is a compliment. As caricatures go of Thomas's opinion, yours is fairly accurate. That is, he is telling us a story of the unfolding of a nation with all of us strapped. The piece that I want to sort of add to that is, I hope I have this this correct, but Alito in the concurrence in Bruin does give it a contemporary spin, which is self-defense, permits I wouldn't say require, but it's certainly the idea that how do you stop a criminal with a gun? By being a law-abiding citizen with a gun. And so there is, I'm not saying he was making a policy argument, but he sort of that is, he raises the idea that here's a contemporary rationale that is consistent with how we're reading the Second Amendment today. And so that was the other aspect of the Bruen case that struck me. As we're talking about who are we as a nation and how do we understand the Constitution, including the Second Amendment today. So those are my thoughts, at least for now.
Well, you made me think of something, and I don't remember whether I saw anything like this. I don't think I read it carefully enough, Alito's concurrence in Bruen. But I was surprised that more hasn't been made. Of course, that wouldn't have been so true, I think, in February, but today, for sure, with the mass shootings, that this argument of saying, if we're as a society invoking language like defunding the police, and if the social contracts took the position that you sign this imaginary contract, and when you sign this contract, you pay your tax dollars, and you will delegate to us rights that you would have under the rules of man that will be forfeited under the rule of law. And that is, we will come protect you, right? And I could imagine one of the conservative justices just rolling out all the crime statistics in Chicago and New York. As you know, we're New Yorkers and we think about this a lot. And I'm surprised that more arguments, it's not a legal argument, but it's the argument that you were making, like, hey, this is a true self-defense argument. And to say, for some reason, it does seem as if in the modern era, the language of defunding the police and with these reformist movements on social, racial justice, prison reform, right? All the changes that have made, I'm surprised more people, you would think conservatives would just jump in and say, yeah, and let's get something straight. I have more reason now to defend myself than I did before. And that's a political argument, and I guess it's extrapolated from that concurrence, but I don't know, maybe you read it more carefully, whether he actually makes that point.
I think the closest he comes, which would be consistent with the extrapolation point that you made, he does, this is a paraphrase, and so I want to be clear that it may not be the most, perfect paraphrase, but this law from New York, it didn't stop Buffalo. It didn't stop the mass shooting in Buffalo.
Yes, that's right.
And that's a paraphrase, but it does pivot to, or it can be a basis to the extrapolation that you made about, we seem to be redrawing the social contract, and if these are the new terms, then a robust Second Amendment or a vigorous right to self-defense that includes firearms is part of that, or handguns is part of that. So I also teach administrative law. I'm going to pivot us to sort of a last question or two about the Supreme Court. I became personally obsessed, it's a fair description, with the Roberts Court, with Chief Justice Roberts, and what was really the Roberts Court in the period when Justice Ginsburg was still on the court before Justice Coney Barrett joined the court, because especially in the area of administrative law, where I think there were 4 important decisions in that term, that last term with Justice Ginsburg, and Roberts wrote all of them. And you could really see, and you can go back and read the news stories and so on. You did something like this for CBS of this is the Roberts Court, and now we saw in the cases that we've discussed, he concurred separately in Dobbs. He joined Justice Thomas's opinion in Bruen, and then from my perspective, this is one of the cases on the last day of the court. He wrote the EPA case, the West Virginia EPA case, which will be is a big deal for administrative law. And so it's just that sense of to what extent do we still have, or can we still refer to, quote, the Roberts Court?
Well, it's interesting. I forgot that one of your teaching areas is administrative law. When I think of EPA case, I think of Roberts not just as an institutionalist, but also as a presidential power guy. I think he was a government lawyer in the White House at some point. And I think people who have that job, who come from that perspective, I think he was with George W. Bush. I think I'm right. He was in that White House as a counsel to the president. Those guys always want to keep options open for the president and the executive branch to make decisions, on some levels. And they certainly don't want agencies to act entirely on their own without any oversight, and might want more federal involvement, like in the EPA case, congressional authorization. So I don't know enough about sort of I haven't really put together all of those opinions to think about, well, where does he come out now? I just know when I think of him, I thought, well, here's a guy that's both an institutionalist and a presidential powers guy, and that maybe that, he's fearful of state government intrusion, of the energy industry intruding, like somehow the power plants have more power than the president. No way, right? The executive branch has more power than, the private enterprise. So I don't know what, I know this, because he's an institutionalist, he's less of an ideologue than some of the other social conservatives on the court, right? Which explains why he doesn't show up as part of the majority in Dobbs. I will say that I still think two things. One is, and I've said this before over the years, justices have a tendency to break the hearts of the presidents who appoint them. They surprise you sometimes. We know this with O'Connor. We saw this with Stevens, certainly with Souter. One could argue with Kennedy. That's a lot of people, Roger, that what? They voted what? I remember, was it last term, Roger, the case, was it Bostic or Bosnick? I can't remember the case.
Bostic, yes.
Bostic, right, with Gorsuch, right? And I'm going, what? The guy from Denver, the conservative from Denver that Trump picked, is the guy that says Title VII on the basis of sex means gay and transgender? What? How does Trump feel about that? How does Trump support? I think that was surprising. I guess Gorsuch hasn't shocked anyone since. I guess there were people who would argue, well, that's a textualist position. It says on the basis of sex. And in his mind, sex means gender. It means any kind of sex that you choose to have. But I do think that that's an example of justices going their own way occasionally. I still think that if there is a swing vote, it's going to be Kavanaugh. And I think that Kavanaugh is going to show himself to be, I think, the one that is not purely institutionalist, but swings ideologically in some ways. But it's still too soon to tell.
Yeah, the two quick comments. I think that Roberts, because I think he did the White House counsel position. He wasn't the White House counsel, but I think he worked in that office. I actually think it may have gone back to the Reagan administration.
Oh, wow.
He was. I think
yes, of course. Of course. Yes. Of course.
I want to check, but that's my recollection.
Yeah, I don't know why I can't. Of course, if he's appointed during the Bush administration.
Yeah, the second Bush is when he
was a young lawyer after working for Rehnquist, I think, as his clerk. Right. Good one. Good one. Good call, Roger. Yeah.
And then but it actually really does connect to your point about Justice Kavanaugh, because Justice Kavanaugh also worked in the White House. And so I think he, from the decisions that I've read, certainly in the administrative law area, in some of the decisions we've discussed today, there is, you could call it pragmatic, you could call it political, and that is not meant to be disparaging. But I think he's willing to sort of think about the court in a three-dimensional way that encompasses a political dimension about this whole thing, meaning government has to work, and as well as we're in some relationship with the people as well. And so I very much agree with you that he is a very important person to watch.
That's a good tie-in. Thanks for that. That was good. That was helpful. Thank you.
Thank you. What do you, I think this will be the last originalism question. Which do you think the next originalist decision is going to, is going to catch our attention coming from the court in the next term or so?
Well, you triggered it, Roger, when a little while ago you said the words Bush v. Gore, because it reminded me of something. Because it reminded me that Bush v. Gore says this is a one-off decision. It has no precedential authority. But if you may remember, and I said this a lot for CBS and even on Newsmax, and I can assure you, I was alone. No one said this because it was really too scary, which was during the pandemic, state election laws for the federal election, upcoming president election, were changed to accommodate the circumstances of a global pandemic. And so there became all sorts of new rules associated with making it easier to vote by mail through absentee balloting, to deliver your ballot so you didn't have to go someplace and stand in line 6 feet apart, right? Social distancing. So all sorts of rules for all obvious reasons were changed to make it easier to vote. And so this election ended up having the vast majority of votes came by view of mail. And that was the first time in American history that the majority of votes didn't come by people standing in line with their ID cards ready to vote in person. And I remember there were 2 emergency appeals before the Supreme Court a week before the election, one in Wisconsin and one in Pennsylvania. And I was reporting on this at the time. No one else wanted to talk about it because it was too scary. And it's because Article 1, Section 4 of the Constitution, and the reason it's important, this is coming up, Roger, as you know, this elections clause case is coming up. And in my opinion, this thing is like Titanic. This is an H-bomb ready to go off for political reasons, because the Article 1, Section 4 basically says federal elections are supposed, time, place, and manner for the rules are supposed to be established by state legislatures. But in the 2020 election, many of those rules were changed, again, to accommodate the circumstances of the pandemic by way of state courts and state election officials. And so some of those cases went up before the election, challenging the changing of these rules on constitutional grounds to say, you can't have late arriving ballots 3 days after the election. You can't accept ballots that are not properly dated. All sorts of questions came up. And I remember it was in Wisconsin, Kavanaugh said the words Bush v. Gore. And I remember thinking, oh my God, he said Bush v. Gore. Because I thought you can't say Bush v. Gore. If you say Bush v. Gore, that means that Bush v. Gore's analysis might apply to a future election. Don't say that. And no one wanted to talk about that. He said it. And I remember saying it and everyone said, shut up, don't say that. He didn't mean it. He was joking. And I remember also Alito had this great line. I'm going to paraphrase it, but it's a little like this. He said something like, in both of those emergency applications, I think maybe in Wisconsin, they did something, but in Pennsylvania decided to do nothing and let the election rules continue as they were modified by state election officials and approved by the Supreme Court of Pennsylvania. And Alito said something like, well, at least can you separate the ballots that come in late? Can you at least put them in a separate pile? Just in case we have to look to see what goes on, we could see what was going on there. At least separate them. You can count them, but separate them. And then Alito says, I think as an aside, I think I have this right, Roger. He says, on the other hand, maybe we should really deal with the merits of this case. Because if we just kick the can on this, this is going to explode in our face and we're going to hate ourselves for this. He says, I think something like that. But no one repeated what he said, but it was a very apocryphal, interesting thing. He said, maybe we really should talk about this because it is an interest. It is a constitutional question. It's the elections clause. So here we go, Roger. This case is coming now before the Supreme Court, and Alito might remind everyone, I told you this was going to blow up in our face, right? What does the elections clause mean? Does it mean that the only rules for establishing federal elections can be done by state legislatures, and there is no oversight, no court oversight, not the Supreme Court of the state, the state election official, the state secretary of state, nobody else gets input, only the state legislatures? Because and I'm going to say this on the Turo Law Review podcast featuring Roger Citron, there are Trump supporters that will hate what I just said, because this is their January 6th argument. This is what some of them are saying, not the ones that charge the Capitol, and they're not the ones part of the big lie. But I've said things like this that have made me exceptionally unpopular because, just for the record, I voted for Biden. I supported Biden, but I understood what was happening in that Wisconsin and Pennsylvania case, and it scared me. And the minute that I saw Kavanaugh use the word Bush v. Gore, I went, oh my God, you don't say the words Bush v. Gore unless you're ready to recount or audit or do something with those numbers to take another critical look. And I think those two things, I wouldn't be surprised coming up if Kavanaugh uses the words Bush v. Gore in the oral argument. You'll laugh if that happens. You'll say, hey, Thane said something about that he says it, and some will turn around and go, wait a minute, we're not supposed to ever say Bush v. Gore again. And Alito says something like, you know what, I think I was right in the Pennsylvania case, because here we are today and we don't know what the election clause means. So anyway, that goes back to the originalism point, right?
Absolutely.
Right. That goes to the point of what did the founders mean? Did they mean in Article 1, Section 4, that federal elections are completely created by the state legislatures with no other oversight, no other intervention?
And I believe the historians are already at work. The legal historians are already at work.
Great.
Canvassing the historical record to help us, including the court, arrive at an understanding of whether how viable the I believe this is the expression, the independent state legislature.
Yes, that's what
theory
it's
is.
Right.
And I we've talked now for about an hour, which is on the longer side for one of these podcasts.
Oh, I'm sorry. That's probably my fault.
It's been delightful, because I thank you. It's been delightful. I think this is a great, right now is where we should close, because in the tradition of the 1930s serials, right, you've left us with a cliffhanger, and we have to have you come back to talk about the independent state legislature case. So, tune in next semester when we come back to see where all of us are.
Always happy to hang out with my buddy on Roger's podcast. So anytime you invite me, Roger, I'll always be back.
Well, it's been a pleasure, and thank you again for your time today. I look forward to seeing you again.
You're a charming host and an interesting and smart guy. So happy to talk to you.
Oh, go on. All right. Thank you.
Thank you.